The state waives opening and the defense may make your final argument. Go ahead, Mr. Wilkerson.
Thanks, Judge.
Yes, sir.
Ladies and gentlemen, told you in the beginning during work here, what I would thank you several times for being here, for sitting through all of this testimony, for paying attention, for showing up, for taking a very difficult job, sitting in judgment of another individual. I don't envy your position at all. You are the most important people in this room. And without you, we wouldn't be able to get these cases taken care of. In the beginning, the state's attorney told you that my job was to create reasonable doubt. But if you think back to what you were told by the court, what we addressed during voir dire, remember where you start. You start at not guilty. It's not my job to disprove the state's allegations. It is their job to prove them and not to just say, well, it's likely this happened, but to prove it beyond a reasonable doubt. And in this case, they just can't. Now, if you focus on a couple of pieces, it would be easy to be perhaps overcome or overwhelmed. But if you look at the totality of the circumstances, which you hear talked about in law all the time, things just stop making sense. What are other reasonable explanations? There are many, many, many possibilities. There's the possibility that the 14-year-old who pointed the police at my client, who likes to pose on social media with guns, and who ended up accidentally killing himself on social media live, was involved in this. I mean, I want you to think about this for just a minute. What the state wants you to really believe. You look at State's Exhibit 7, right? Think about where all of this started. 10 minutes before Officer Stimson was back on scene, he was watching this defendant, the deceased, and two other girls talking in this area between these two buildings. So in 10 minutes, and the decedent, what's he wearing? Skin tight shorts, right? So the state wants you to believe that in 10 minutes, the decedent walked over here, the defendant obtained not just a gun, but a knife, which the state doesn't address at all. Doesn't tell you anything about a knife, doesn't tell you where a knife might have gone, where it might have come from, doesn't account for how somebody stabbed and then shot somebody, especially if they were holding them at the same time, doesn't account for a second person perhaps being involved. But during that 10 minutes, something that he couldn't hide on his body, you can look at the clothing that he was wearing and see that in Stimson's video that there's no gun, there's no knife, there's no nothing. He's outside building 11 and 9 with the kids, with the door open, kids coming up and downstairs and coming outside. Did he leave the kids alone? Leave the kids alone, go obtain a gun and a knife and ammunition, make the 2 to 3 minute walk over to the back of the building, shoot the decedent, take off running, dispose of, oh wait, because he also had to get rid of the decedent's pants, right? Somebody took them. So what did he do? Did he stand there after stabbing and shooting the decedent, who he had no reason to do either to? What, did he stand there and pull them off? Did he cut them off? What? Where'd they go? Because Officer Stimson's back in 10 minutes and the decedent walks up during the investigation, right? He told you he left the kids in the apartment, told the oldest, look, I'm gonna go see what's going on while all these lights are flashing. I'll be right back. How is it even possible that the sequence of events that the state is presenting evidence took place? So when you start looking at what state's going to tell you is the insurmountable evidence that this defendant is responsible for this murder, they want you to ignore all of that. And they want you to focus on, okay, well, his DNA, maybe, they're going to tell you it's his DNA, right, was on the rim of the shell case. Now let's talk about that shell case for just a minute. That shell casing, circumstantial evidence would say that it's related to the murder because there's a body there, right? Well, we're in a high crime area where multiple witness officers and residents told you they're shooting out there all the time. We talked about transference of DNA, of GSR. If I pour powder on my hand, walk up to you and shake your hand, you've got powder on your hand. Does that mean that you put it there? No. It just doesn't make sense. They're going to tell you about GSR. And they're going to say, look at the component particles. And they're going to tell you that because the immutable truth given to you by their own expert is there is no GSR in this case. Doesn't exist. Can't say it's GSR. Why? He sat there and told you. Well, because there are sources. I mean, talked all about morphology, etc. Remember, I asked him. So, if all these advances in science, and you look at these things, right, and you can narrow it down, and you could say, well, it might came from this because of these qualities, but you still can't say that it's GSR. No. Well, because it doesn't have all three. Then, presuming that the shell casing on the ground is the shell from which the bullet that killed the decedent was related, tell you, after telling you, okay, we got an electron microscope that's going to look at this sample and find lead, antimony, and barium, that they don't have a way to test the shell casing to see if there was lead there. Remember lead-free bullets? That's how they wanted to explain away the absence. But let's suppose for a minute that you believe that came from the defendant firing the weapon. Where's the blood spatter? Oh, and before I completely leave GSR, before I forget, let's also remember that their own expert told you that the gun is pressed against the body, not just the forensic medical examiner, but also the officers. Talk about the burn marks, talk about the impression of the muzzle against the skin, talk about the gases and powders being discharged into the body. And that is the reason for those markings, and that's the reason they can tell you that this shot took place at point blank range. And if they say, well, there's no blood spatter on his hands because he washed them, okay, well, which is either he washed his hands, so the component particles wouldn't have been there because he washed his hands, or he didn't wash his hands, and you're missing DNA from the decedent that generally is going to happen with a point blank shot. Now, it's not guaranteed, but nothing in this case is guaranteed. We are dealing in probabilities, ladies and gentlemen. We are not dealing in certainties. Their DNA expert couldn't tell you, yeah, that's his DNA. Remember, she was asked many times. Well, it's consistent with his profile. If it came from an unrelated, unknown individual, 4,950,000. If you can't agree, do not change your verdict unless you are convinced by the evidence that this defendant is guilty. It's the last chance I'll get to talk to you. Do what your duty requires of you. Do what your duty requires for every citizen. That protection that is offered by a jury trial, by holding the government, the state, to account by requiring them to prove the case beyond a reasonable doubt. If you do that, please, gentlemen, I would suggest to you that your duty is clear to find the defendant not guilty. Thank you.
All right. Thanks.
Thank you. Ladies and gentlemen, Mr. Wilkerson and I may disagree on a lot here. I'm going to start off by agreeing with him and thanking you all for your time and your attention this week. I know you've heard a lot and you've seen a lot coming from that stand. The best witness that we could ever have to come and sit on that stand to testify to you this week, he's dead. He can't. So because of that, we have to bring witnesses and we have to try to piece together the truth. I said it before, I'll say it again. Defense counsel repeated after me. His job here this week, he doesn't have to present evidence to defend his client. He didn't have to take the stand, but I knew he was going to try to muddy the water. So if you think about a room full of smoke and the door's over there, or in your case, the door's over here, and every single one of you needs to get out. It's going to be hard. It's not going to be easy, but you're going to figure out how to sift through that smoke and you're going to make it to that door. And that's what we're going to do here for the next few minutes. I wish that I could tell you the why. I wish that I could break it down and tell you why in the world did Brandon Charles kill Jhamiah Dixon. I can't. Killers kill for many reasons. The good thing about it is I don't have to be able to tell you why. The law sets it that way. The law knows that I can't get inside of the head of every killer to figure out why they move the way they move, why they do the things they do. The law supports me on that. As I told you at the beginning, also, this is going to come down to the DNA and the GSR. So we'll sift through some of the other things, kind of like a funnel, until we get down to where we need to get to. So what do I have to prove? Brandon Deion Charles Jr., on or about July 19th, 2023, in Jefferson County, Texas, intentionally or knowingly caused the death of Jhamiah Dixon by shooting him with a firearm. I can say that defense and I probably agree on those last 5 elements. There's probably no disagreement there. The disagreement comes on element number 1. Was it Brandon Deion Charles Jr.? So all of the witnesses that I brought you was to show, yes, that's who it was. They brought you to Kendria. She testified that she
Your Honor, if that's not evidence and the picture not evidence.
Okay. It's, the jury knows what the witness looked like. That is the likeness of what the witness appeared to be. And the jury will give how much weight and credibility it deems it deserves from the evidence presented. But the state of Texas and the defense can use what occurred, or a likeness of what occurred in evidence during final argument.
She said she left home about 1 for that last time that day before she came home after police were called. So she left home about 1 p.m. And she says that when she left home, Brandon was dressed like a man. When I asked her about the wig and the cross-dressing, she seemed surprised. She said that makeup, no, he didn't have on makeup. Yeah, he wore a lace front wig sometimes, but makeup, no. She also testified that when defendant was at her apartment, he came there and he was watching her kids and she was gone. It sounded like that was the normal thing for them. That Kendria had the kids, she had the apartment. It was a way for Brandon, being 17, to get away from home, get away from the parental requirements from home and go to her house. His agreement was to watch the kids, but she was going to be gone, so then he could do what he wanted to do. Defense counsel tries to bring up about Brandon leaving the kids in the house. That was a norm too. They were outside talking when the police was there before the shooting happened. So it was normal for him to leave those kids in the house and go outside and hang out. So that's nothing different. Judge talked to you about making inferences. We talked about making common sense. So I'll tell you, using your common sense. So I'll tell you what her testimony meant to me when they called her. When DeKendria was home, Brandon dressed like a man. That's who she knew him as. She knew him as a man. She knew him as a 17-year-old boy. When DeKendria left, that left Brandon at home with Jhamiah, and then the kids were running around doing what kids do. That's when Brandon changed his appearance. Brandon became the woman after DeKendria left. Brandon's sexuality isn't a secret. They said he's gay, he likes women, he likes to cross dress, and I'm going to also agree with defense counsel. That's not an issue here. I'm not here to judge Brandon on what he does as far as his sexuality and his cross dress. That's his business. But I do believe it had to do with him trying to make a certain impression on Jhamiah. Now, I can't tell you what Jhamiah's sexual preference was. I can't tell you if he was gay. I can't tell you if he was straight. I can't tell you if he was curious. But I can tell you that something went wrong in DeKendria's apartment that day. They brought up defendant's mom. She wasn't there, so her purpose was to come up here and talk about his nonviolent, peaceful character. And then she minimized the incident. And defense counsel tries to minimize the incident too. He was having an altercation with his mama. The thing that stopped him was that the neighbors heard the altercation. So he didn't jump on or hit or attack his mama or do anything else like that to his mama. He didn't get to spit on his mom because the neighbors called the police and the police came and stopped it. So it doesn't matter how she wants to minimize the event, the incident that happened. He was in an altercation and about to spit on his own mama. The person who gave birth to you, the person who you're living in their house and they're paying the bills because you don't work. And you think enough of her that you're going to spit on her and disrespect her? So who is Jhamiah? Nobody. He doesn't care. There's no respect there. Then he put on that investigator. She puts Jaron in the very apartment to where he has bird's eye view on what's going on down there. And then defense counsel wants to turn it and say, well, maybe it was Jaron who did it. Guess whose DNA was not on that shell casing? When the forensic chemist talks, she talks about there possibly being two profiles on certain things, and then it would tell her that it's another person's profile. Not here. It's a single individual. And when we say single, he's right here. That's whose DNA was there. The chemist told us about the math she did. I'm not up here to try to tell you how to understand the math. But from everything she said, it was very strong support. That was the highest level they can get. Very strong support for the proposition that Brandon Deion Charles was the contributor of the profile. It's 4,950,000 times greater than the probability of obtaining the probability from him than any other unrelated unknown person. What that tells me, if there were more locations of identity for that casing profile, that 4.95 million just goes up and up and up. But no matter how far it goes up, we can't get anywhere higher than very strong support. You heard from the pathologist, contact gunshot wound to the back, and it was homicide. The box we didn't think was checked off is checked off. Brandon got up there and the only thing he knew to say, well, it must have been transferred or cross-contamination. Well, he's been sitting here the whole time. He's heard everybody talk, and that was the best go-to. How was your DNA transferred? If I come and shake your hand and I go touch my purse, both of our DNA is going to be on my purse. Not just yours. Our DNA is going to be on my purse. Nobody else's DNA was on the shell casing. Only the person who shot Jhamiah. I can't tell you which way Jhamiah was running at that gate. I can tell you that from that pathologist photo that when Brandon shot him, he was right there and he put the muzzle of that gun right on his back. And you can see it in those photos. That was up close and that was personal. No one who got up here had anything bad to say about Jhamiah. They said he was drinking that night. His BAC was 0.34, so it's 0.234. So he was probably intoxicated. He was smart enough to get in the car with someone when he left, so that's not a crime. But what that BAC does tell me is that he wasn't able to fully protect himself. Could we have the wrong person? Sure, if you close your eyes and ignore the evidence. But the evidence tells us that it was Brandon Charles Jr. Jhamiah wasn't as lucky as Brandon's mom. When his mom was in the harm's way of Brandon's wrath, when he's angry or doesn't get his way or whatever he's mad for, the neighbors heard, the neighbors called the cops, and the cops came and intervened. Jhamiah didn't get that same chance. When Jhamiah got caught in whatever reason Brandon was upset, whatever made Brandon snap like a light switch and do what he did, there was nobody there to intervene. Ladies and gentlemen, when you go back there, it's time for justice for Jhamiah. Jhamiah didn't deserve to die like this. Jhamiah didn't deserve to be left laid out like this. When you go back there, I ask that you look at the charge. On that page that says charge, it doesn't tell you I have to ask you about a motive. It doesn't tell you I have to ask you to prove to you where the gun is. When you go back there, I ask that you find this defendant guilty of murder of Jhamiah Dixon. Justice for Jhamiah and justice for his family. Thank you.
All right, ladies and gentlemen of the jury, this time I'm going to tender the jury charge to the bailiff. I'm going to ask you to please step down from the jury box, follow the bailiff into the deliberation room, and we will await your verdict. And the alternates, and we're going to ask you to wait patiently outside. And we've, in the past, we've done this law so many times, we've had to replace jurors during deliberation. So we're going to ask you to hang in with us until the end. Thank you very much, and we'll keep you updated. The record shall now show that the jury is seated in the courtroom. Ladies and gentlemen, Mr. Wilkerson is present via video in his vehicle. He's pulled over and he had to go to an important health meeting that he needed to make this afternoon. So he is going to be listening and watching live through the video. There he is right there. And the defendant is present. The prosecution is present. And again, for the record, the jury is present. The court has received a message from the jury that the jury has reached a verdict, and I'm going to talk to Mr. Cross. Is that so, sir?
Yes, Your Honor.
Is this decision a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, Your Honor.
And did any of the jurors disagree with your four persons representations? No disagreement. It does indeed appear to be a unanimous decision. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict of the jury. The defendant shall rise. In cause number 23 CR 1121, the state of Texas versus Brandon Deion Charles Jr., we, the jury, find the defendant guilty of the offense of murder as charged in the indictment. This verdict signed by the foreperson of the jury. It is received and made a part of the record for all purposes. You may be seated, please. Thank you. Ladies and gentlemen of the jury, I have, and anybody, if y'all have to leave, please leave, but do not make outbursts. All right, at this time, I have received your verdict, finding the defendant guilty of this first-degree felony of murder. That brings us to a close of phase one of this bifurcated two-part system we have in the state of Texas. We will next proceed with the punishment phase of this trial. And once again, let me repeat, you are still under all the instructions previously given to you in this case. Ladies and gentlemen, here's what's going to happen because the defense attorney is unable to be here this afternoon because of an important medical reason. We are going to pick up Monday morning, 9:30 in the punishment phase of the trial. Punishment phase is always much shorter. presentation of evidence can be made by both parties, then the court has a shorter uh, uh, jury charge to give to you. Then the lawyers make their final arguments, and you go back to deliberate on the issue of punishment. So these instructions, remember, stay muted about these events until you are released at the end of all of the proceedings and that should be ended by Monday. People will ask you, what can you tell me? Remember, still the same instructions. Don't talk about this case yet. The proceedings, your deliberations or anything until the end of the trial when you are released, and that will probably be Monday, unless for some strange reason it would be prolonged, which we don't expect that to happen. But nonetheless, we're scouts. Be prepared, and anything can happen. But this is what normally occurs. So don't talk about this case at all with anyone, and we will ask you to return back at 9:30. Then the parties get a chance to present any evidence they want for you to consider for the punishment phase of the trial. The court has a much shorter set of jury instructions for this second punishment phase. I will read those to you when the evidence is presented. The arguments will be made by the attorneys, and then you will go back together to deliberate on a verdict. That's our plan. All right. So what we're going to do is release you with those instructions, and be very careful about following them, as I know you will. And we will see you back at 9:30 Monday morning for the punishment phase of this trial. Anything to bring up by the prosecution?
Nothing from the state, Judge.
Marcus from the defense?
Nothing from the defense, Your Honor.
Thank you. All right. You are excused, ladies and gentlemen. Thank you, and have a nice weekend. Thank you, man. Thank you.